do so in order to increase just a little bit at the margin, which is what this is, state power to get in the game and check federal power. And when you go to your colleagues in the state legislatures and they ask you, well, why are we doing this? Why should I do this? You have to say to each one of your colleagues, who may not be of the same ideological persuasion as you are, but you might have to go up to each one of your colleagues and say, well, I don't know, how would you like just a little more power? Just how would each one of you in the state legislatures, how would you feel about having just a little more power? Now, you may have some colleagues who on general principles say, no, we don't want any more power. We're happy with the power we've got. We're happy with the federal government having power over us. But there might be some other colleagues who might say, no, it might be a little good idea for each one of us to have a little more power. And so let me just basically conclude by saying this. The problem we have now is we have a literally or virtually unconstrained federal government for the two reasons I talked about, spending and regulations. And the courts are not going to be the ones that are going to rein them in, except at the margin. I'm very heavily involved, by the way, in the Attorney General lawsuit in Florida, and so I know what's going on there. I'm hopeful, but I'm telling you, the courts are not our savior here. What we need is a structural check on federal power. Where can we place that structural check? Who can we put? We don't have a national referendum as a check? I don't think so, and I wouldn't want that. The only people out there who can provide that structural check that are already in place, that are up and running, state legislators. You guys have to stand for election. You guys have to serve. You have state houses. You have voting mechanisms. You're already in existence. That's where you reside. That's the only place we can put the check. And so that's what the repeal amendment does. So the last thing I want to do is introduce to you two people who have been very involved in this. First, I want to introduce Marianne Moran, who's directing the repeal amendment initiative. Marianne, would you stand up? There she is. Look, unlike the president, I really am a law professor. And but also, unlike the president, I am not a community organizer. Marianne is the community organizer. She, if you're interested in the repeal amendment, I'm not the guy to talk to in terms of saying what can I do and how do I coordinate my activities with, for example, the president of the Florida State Senate, the Speaker of the Utah House, the Speaker of the Virginia House of Delegates, the Speaker of the Texas House of Representatives. These are the folks that have already signed on to the repeal amendment. Oh, by the way, it's also introduced into Congress by Congressman Rob Bishop. On Tuesday, he introduced that into Congress, and he'll reintroduce it into the next session of Congress. So, that was the one thing I forgot to tell you. This Article 5 threat, this brandishing of the Article 5 gun that we're talking about, the ultimate hope of this is not to get a convention. There's never been a convention in the history of this country. The ultimate hope is just to get 2/3 of Congress to propose this amendment. And then that eliminates any need for a convention. But if you don't threaten the Congress with the gun that's been given to you by the Constitution, they're not going to do it. So that's the girl. Oh, that's the first person I want to introduce you to. The second person is Rob Nadelson from the Independence Institute. Rob is a recovering law professor from the University of Montana. Now he's with the Independence Institute, and he's done some path-breaking constitutional scholarship on the history of the Amendments Convention process, how they've been used in the past, how they are in fact limited, and he's a constitutional expert on that subject. So I just want to thank you all for being here today and paying attention. Thanks.
Thank you. So we've got about 10 minutes for maybe 3 or 4 questions. If folks want to come up, Trent, I see you're headed for the mic. Is that right?
That's right.
All right. Well, we've got our good friend Trent England up at the mic with the first question.
That's right. Mario knew I couldn't resist. No, Nick and Randy's scholarship, Professor Nadelson's scholarship, I think on this is outstanding. I do think you cheapen your argument a little bit if your illusions are to dissuade people from taking seriously the arguments made by heroes like Phyllis Schlafly and serious attorneys like those at the Heritage Foundation. I'd like your comments, because I do want to make this a question, on, isn't there an additional level of prudence, of practical wisdom and caution that's involved as we deliberate about constitutional change and opening a door on a new, in the sense that it's never been used before and there's no precedence on point, a new avenue toward constitutional change, and what kind of, you've talked about an amendment that you support. One of the problems that I have is, as soon as this argument comes up, you hear all kinds of proposals for amendments, which is one of the problems. You know, a progressive law professor said at the Federal Society a few years back, I support every attempt to change the Constitution because it diminishes the importance, the reverence to the Constitution. What kind of amendments, how should people think about amendments? As legislators are having all kinds of proposals brought to them, what is the prudent way to think about what kind of amendments are appropriate and what kind are not? It'd be nice to hear some specific examples of what kind of amendments are problematic. Thank you.
Thanks, and I certainly didn't mean to disparage my friends at the Heritage Foundation, who are actually literally friends of mine. In fact, I wrote the policy report for Heritage with my friend Todd Gaziano, which started the argument against the constitutionality of the individual mandate and initiated the Republicans' constitutional objection, which began us down the path of challenging the individual mandate when all other law professors thought that this was frivolous. The Heritage Foundation was there to initiate this intellectual initiative which preceded the legal one. So I have great respect for my friends at the Heritage Foundation. However, I have to say that just because someone's a conservative doesn't mean they're always right about the Constitution. And of course, I'm in favor of prudence. And that's why I said we have to ask ourselves, are we living in normal times or are we living in extraordinary times? And here's what I'll say just about the objections, and then I'm going to say a little bit about what's good and what's bad. Here's what I say about the objections to it. The objections are universal to any amendment, Article 5 invocation, period, end of story. They are not nuanced, and they are not based on prudence. They are just based on the imprudence of ever doing an Article 5 process. And that, you know, if you buy that argument, if you agree with that argument, well, that's fine. I respect that. But I'm just saying, it's not a nuance this versus that. It's never, ever, ever, ever is the argument you're really going to be hearing from the people who oppose the Article 5. And that's sort of like unilateral disarmament. You're taking a weapon that the founders gave you in Article 5, and you're going to say, we will never, ever use that weapon out of reverence to who? Out of reverence to the founders. All right, so that doesn't, to me, I think that's an argument against that. Now, I do think there are prudent and there are imprudent amendments, but really remember this, Congress already has a power to propose, with 2/3 vote, amendments to the states. They have an unlimited power to propose an unlimited number of amendments right now. You could have a runaway Congress proposing amendments. They don't do it because only some amendments have political salience and others don't. I was recommending to you focusing on structural changes, like the repeal amendment, which doesn't talk about any specific law. It doesn't talk about Obamacare. It doesn't talk about cap and trade, and it doesn't talk about unfunded mandates, though it could reach any of those things. It's just a structural amendment that you have to ask yourself, as a matter of general principle, does this make the Constitution better, or does this make the Constitution worse? And that's how I would approach it. Not whether this gets me the result I want, because that's what the progressives like. They like making exceptions to get results, because that's what they've been doing in the courts. So they'd be happy to do it with amendments, too. They could get amendments, they wouldn't need to do it in the courts. I'm suggesting there's the criteria you should use. Is somebody proposing to me a structural change that will make the Constitution better? We've changed the Constitution for the better. The 14th Amendment has changed the Constitution for the better. The 13th Amendment did it too. Unfortunately, the 16th and 17th Amendments may not have changed the Constitution for the better, but you have an opportunity to do that. That would be the criteria of prudence that I would ask you to adopt and apply.
And if I could just jump in on that too, I think that as soon as the election of this year was done, people were saying, well, you know, how are the Republicans going to be able to keep this together, and how are they going to be able to use their majority in the House, and questions about how can the movement maintain consensus. And I was just reading actually yesterday on the flight up here about